Hello everyone, I am Dr. Sarfraz Ahmad Khan. Today we are going to discuss very important topic in law of evidence, namely presumption. We will cover this topic in two parts. First part will devoted to the one of the component of presumptions, namely presumption of fact. So when we talk about presumptions, remember it is one of the concept of evidence law which uses in judicial processes the concept of presumptions in order to seal the gap which may exist in facts on record in a particular case. So what happened in many cases where the evidences are produced, when we prove something in court, everything does not prove by the direct evidence which is produced in the court, but there are many occasions when court can draw inference, court may draw some presumption. Law recognizes those kinds of presumptions. So it is normally said that when we look at the presumption, it says the bats of the law flitting in the twilight but disappearing in the sunshine of actual facts. Presumption can help in some cases, we can draw presumptions, but if the actual facts are there, then presumption has no role. But there may be some circumstances when the actual facts are not available and we have to draw some inferences in the given circumstances. Now, in our day-to-day life also, we draw some presumptions, we draw some inferences. The kinds of inferences we draw in our day-to-day life, the law of evidence also take into account them, and accordingly, the presumptions principle has been incorporated. Presumptions are used so as to save the time of the court. When a fact is presumed to be true, the court need not spend its time in determining its veracity. It may, however, disbelieve the fact if the evidence is adduced in order to disprove it. Impliedly, if some facts are presumed by the court, the other party has liberty to give evidences to rebut those presumptions, and that possible under the law. When we look at presumptions, it is basically, we can say, it's inference. To give you example, for example, there are some basic facts, and from their basic facts you draw some inferences. So there is a primary fact, say someone has not been heard of by their family member from last 7 years. Had the person be alive, he must be heard of by their wife, spouse, parents, children, but the person is not heard of from last 7 years. What we can presume? We may presume he is dead. Law permit these kinds of presumptions. Someone may be standing. So 4 or 5 persons are standing on the road, 4 students, they are talking to each other. Suddenly one person came that, okay, yesterday someone has committed theft and police is looking for it. Among those 5 persons, one run away. Why he has run away? Might be some connections. Now, there are many things which we presume, we can infer. In our day-to-day life also, we draw some kinds of inferences by action of some persons. Law recognizes those kinds of presumptions. Law recognizes those kinds of inferences. When we use the word presumptions, broadly, the presumptions are divided into 2 major categories. One we call presumption of law, other we call presumption of fact. Now today in this videos, our lecture will be consist of one presumption of fact only. In law or in the Bharatiya Sakshya Adhiniyam, they use the word may presume. Now many times this word may presume or presumption of fact we also call natural presumption. Why we call natural presumptions? Because we naturally infer something. It's not that we require some law degree to draw some kinds of inferences. It does not require that some kinds of a very special knowledge to infer that inferences. We normally draw that inferences in our day-to-day experience, our human conduct, behavior. So many things we can draw inferences. We call it natural presumptions or presumptions of fact. Natural presumptions are always rebuttable, implied. If some facts are inferred, the other party may give evidence to rebut that presumptions. It's possible under the law. So the law or the word which is used in the Bharatiya Saathe-Law to explain the term may presume, natural presumption, is the word may presume. What it says? It says whenever it is provided by this adhiniyam that the court may presume a fact, it may regard such fact as proved unless and until it is disproved, or may call for proof of it. Accordingly, when we use the word may presume, we also call it discretionary presumption. It's not mandatory, because the court has the option either to presume or may call for proof of it. But if the court presumes something, then that will be considered as proof unless and until disproved. So that is the natural presumptions or presumptions of fact. To give you some examples, for example, say someone purchased some goods from Amazon. Now Amazon, all the records says that the delivery is started, it's delivered to different persons, it delivery made to the persons whom are there, some password was given to delivery, the person must have been given password, that's why delivery has been given. So the password or passcode goes to the mobile number of the consumer. Now from this fact that the delivery boy given all the document they have submitted about the starting of delivery, password communications, etc., we may presume it must have been delivered. So if few basic facts are there, from that fact we can draw some inferences. Now if someone says, no, I have not received it. Now if the court is drawing presumptions, then it will be considered as proved unless and until it is disproved. So the person who is claiming that he has not received or she has not received, they have to rebut that presumption. Or court may say, no, it's not enough, you require some more evidence to prove. Then court may call for proof of it. Accordingly, these kinds of a presumption which we draw naturally from circumstances, we call it natural presumption or presumption of fact. What is the second category? Now, second categories of presumptions are basically we call two categories are there, two words are used. But the second category is broadly we say presumption of law. And in presumption of law, again there are two categories there. There can be rebuttable presumption of law, irrebuttable presumption of law. When it is rebuttable presumption of law, impliedly other party can rebut that presumptions. They may give evidences to disprove it. When law says irrebuttable presumption of law, then the other party will not be allowed to give any evidences. It will consider as proof, no other questions, no other evidences. So accordingly, irrebuttable presumption of law is used only in limited circumstances. By and large, what we find, shall presume. So when we say artificial presumption or rebuttable presumption of law, the word in Evidence Act or Bharatiya Saathe-Law is used is shall presume. We call it artificial presumption. Why we call it artificial presumption? The reason being that law artificially impose an obligation that court has no other option but to presume that fact. When any law, any statutes use the word court shall presume, that means the directions on the court that if those basic facts are proof, from those basic facts, court has no other option but regard such fact as proved. Subject to unless and until it is disproved. So what the shall presume, what definition says? It says whenever it is directed by this adhiniyam that the court shall presume a fact, it shall regard such fact as proved unless until it is disproved. That means here court has no discretion. It artificially imposes on the court. Court must draw an inference unless the fact is disproved by the evidence which has been adduced to disprove it. So it will be considered as approved unless the other party disprove it. This is sometimes called compelling presumption. We are forcing the court to presume. To give you an example, say for example in a rape case, a girl alleged that she was forcibly or without her consent, she was sexually exploited. In the court, she has given evidence that she has not given any consent. Law says court shall presume there was no consent. Why will draw presumptions? The girl's statement may be true, may not be true. But here, court has no discretion. It's a obligations on the court mandatorily to presume that there was no consent. We know there are many cases. For example, there was a very famous case from Tripura which started. It's a Bodhisattva Gautam versus Subra Chakravarti, where a girl was in relation with a person, Bodhisattva Gautam. Even the relation goes for quite long time, and the girl has undergone abortion 3 times. Now, in those kinds of cases, naturally what presume that if someone has a longer time relationships, there might be this relationship consensual. But evidence law or Bharatiya Sakshya Adhiniyam says if the girls give evidence in the court that she has not given consent, or consent was not voluntarily obtained, or consent was misguided, which is not voluntarily in nature, conditional something, court has no other option, but court shall presume, court will consider this as proved that there was no consent. Now it is open for the accused to give evidences to rebut it. So why we call it compelling presumptions or artificial presumptions? Because there might be some circumstances where naturally we may not draw that inferences. But law says artificially that no, you have no other option, but you shall regard such fact as proved unless it is disproved. So here, sometime it might come naturally, sometime it might not come naturally, but court has no discretionary power. Court has to draw inferences. The fact is considered as proof, and accordingly we call them artificial presumptions and or rebuttable presumption of law, because this fact can be rebutted by other party. When it is rebuttable presumption of law, when it uses the word shall presume. The third word which used in respect of the presumption is conclusive proof. It is again artificial presumption or presumption of law, but it is irrebuttable presumption of law. You cannot rebut it. So when a law says some fact as conclusive proof, law considers such fact as proved, and the last part says shall not allow evidence to be given for the purpose of disproving it. So conclusive proof implies when one fact is declared to this adhiniyam to be conclusive proof of another, the court shall, on proof of one fact, regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. So here, when the word used conclusive proof, court has no other option but to consider such fact as proved, and court will not allow any evidence to be given for the purpose of disproving it. under the law, only in limited circumstances the word conclusive proof is used. So, the court cannot allow a rebuttal or any evidence to the contrary. It is established fact. So, what is open to attack, however, is the fact upon which the conclusive presumption is based upon. So, from the prima facie fact from where we draw the inferences, you can challenge those prima facie fact, but once the inferences is drawn, that cannot be challenged because it's artificial presumptions, and court draw presumptions that it is conclusive proof. You cannot give any evidence to rebut it. Accordingly, when we look at the Bharatiya Saksha Adhiniyam, particularly the issue of presumption, broadly presumptions can be divided into two categories. One we call presumption of fact. I use the word also, it's a natural presumption. Other side we have a presumption of law, artificial presumption. This presumption of law again divided itself into two categories. One you will find rebuttable presumptions, other you will find irrebuttable presumption. If you look at Bharatiya Saksha Adhiniyam, you will find these all provisions are there in the Act which talk about presumption of fact, 88, 89, 90, 92, 93, 117, 119. When you look at rebuttable presumptions of law, 78, 79, 80, 81, 82, 83, 84, 85, 86, 87, 91, 108, 118, 120. So, all these sections talk about rebuttable presumption of law. But when we use the word irrebuttable presumption of law, conclusive proof, only two places you will find in the Bharatiya Saksha Adhiniyam. One in section 35, where some specific kinds of judgment etc. of the court, which are judgment in rem, has been declared as conclusive proof, will probate is granted, conclusive proof of the fact. So, some judgments which give status, those are conclusive proof. Or 116, which is basically child born during subsistence of marriage. So, when a child born during the subsistence of a marriage, husband and wife living together and child born, it's not a guarantee that a child born, a person might have a illicit relation. There are many occasions when a woman might have a relationship with someone else. But the child born during subsistence of marriage, during wedlock, the law says it is conclusive proof. If the child born during subsistence of marriage, it's a conclusive proof that the child belongs to that parents, husband and wife. Why these provisions? This provision is for protection of children. So, even if some person has an illicit relationship, but the child who begotten, the child has not done anything wrong, and accordingly child needs protections. So, law has given a highest protections, and it says it's an irrebuttable presumption of law, conclusive proof that a child belongs to them, subject to some exception. We will discuss in the next videos, where we talk exclusively on these two sections, irrebuttable presumption of law and rebuttable presumption of law. We will discuss both. There we will discuss in detail. So, today our focus will be on presumption of fact. So, there are many places in Bharatiya Saksha Adhiniyam, they talk about may presume or presumption of fact, which we call natural presumptions or may presume. I already said to you. So, we find in many places this word may presume is used. For example, presumption as to certified copies of foreign judicial record. Remember, if any foreign judicial record certified copy is produced, law says court may presume them to be true certified copies of those judicial records. So, the presumption is there, court may presume them. Why they add this kind of presumption? Now, it helps in proving the cases, it helps in proving those documents, it helps in saving the time. Suppose if this presumption is not there, then all those documents need to be proved independently. It requires lots of court time. Because the certified copy from foreign judicial bodies, court may presume it to be true. So, court can proceed further, it can save court time. If the other party says, no, this is not the true copy, there might be some manipulations, etc., the burden is on him to disprove it. So it's a discretion of the court to draw an inference. Now, not mandatory, but court may presume that the just certified copy may be true. Same way, under section 89, presumption as to book, maps and chart. Suppose we all see in our day-to-day life, when we go for somewhere tour in some other states, we always buy some books on the map of that cities or locality. So TTK map is a published map. Now, when you look at those TTK map or any book where the map of the city there, you went to Darjeeling, you went to Shimla, you went to Manali, you went to any other cities, and you have a map of the cities. What we naturally presume, it should be true when it is published. Now, when something is published, it gives some guarantee that anything is published, it is always available for criticism. So, had there is some mistake, someone could have pointed out. And accordingly, law says court may presume that any book to which it may refer for information on matter of public or general interest, and that any published map or chart, remember the word published is there, published map of chart, the statement of which are relevant fact and which is produced for its inspection, was written and published by the persons at the time and place by whom or at which it purport to have been written or published. So, they may draw some kinds of presumptions in respect of those map, chart, etc. So, we call it natural presumption, because when we look at those printed book also, we also get some naturally understanding that it must be true map. Law recognizes court may draw some kinds of naturally some presumption. Similarly, section 19 talk about presumption as to electronic message. For example, one of you has sent an email to your friend. So, from your email account, the mail has reached to your other friends. What is the presumption? The presumption is that from this email account, the mail has been sent to other email account. But here, law makes very clear. You see the second last part. But the court shall not make any presumption as to the person by whom such message was sent. So, suppose from your email account, a message has been sent to your friend. The presumption is only from this account, the email sent to other account. But whether you sent or someone else sent, there is no direct presumptions here. However, if it is my email account, I have my password. Again, this is a natural thing that I should have some access. I only have access. So, no, but it's on the court. So, this provision does not say about the person who sent the message. This provision only says there will be presumption that it's sent from one account to other account. That's what the presumptions the law is being drawn under section 19. In the same way, say section 92 talk about presumption as to document 30 years old. Some old document produced from proper custody. Look the provision what it says. When any document purporting or proved to be 30 years old, so very old documents are there, is produced from any custody which the court in the particular case consider proper. That means it is coming from proper custody. So, my grandfather's property deed, I have in my possession, being the eldest son in the entire family. I am keeping this deed. Suppose my custody is proper custody. So, if I bring that document, if the issue arises of any property related dispute in the court may presume that it is a true genuine copy of it. So, court may presume that the signature and every other part of the document which purport to be in the handwriting of any particular person is in that person's handwriting. And in the case of a document executed or attested, that is was duly executed and attested, but the person by whom it purport to be executed and attested. So, some presumptions are there. Why this has been added? Remember, under the law of evidence, there is a very rigid requirement of quality of documentary evidence. So, the law of evidence says, suppose if a document require attestation. Now, attestation here does not means what many of you might be thinking, that a gazetted officer sign your result and true copy of it. This is not attestation. You went to some police station, any gazetted officer in charge put signature, your headmaster put signature, there is a true copy of result attested. That is not attestation here. Here attestation means when a deed is executed, say sale deed. And the sale deed, two witnesses has signed. Someone made a will, two witnesses has signed. What the witness is doing? Witness is executing or attesting the execution of a will. Witness is attesting the execution of sale deed. Witness is attesting the execution of trust deed. So they are all attesting witnesses. Now, so evidence law require, if some document required by law to be attested, then to prove those document, what you require is you require at least one attesting witness should come to the court. Now, some document is 50 years old, 60 years old, 80 years old, 100 years old. The attesting witness might not be alive. It is difficult to bring them. So, because of this presumption, it may help in proving. So, if document is coming, old document coming from proper custody, court may draw presumption that was properly executed, properly stamped. Because many evidences which you might ask today of a document which is 100 years old, 70 years old, 60 years old, we will not get those witnesses. So, presumption, it helps in many time proving a document because it saved the court time. If had it not been there, then you have to prove those signature. You have to prove those attesting witness signature. You have to prove that it was properly stamped. When it is presumptions, through presumptions, court may presume its existence. So, presumptions helps in proving those particular facts. There are many illustrations has been given in this section. So, A has been in possession of a landed property for a long time. He produced from his custody deed relating to land, showing his titles to it. The custody shall be proper. A produces deed relating to landed property of which he is in mortgagee. The mortgager is in possession. The custody shall be proper. A connection of B produces deed relating to land in B's possession, which were deposited with him by B for self-custody. The custody shall be proper. So, it defined the word what's the proper. So, if there any document which come from proper custody, old document, court may draw presumptions and presumption helps in proving those cases. So, presumption which is used, the old law, it was section 90, has to be applied as the law stand only to originals and not to copies. That's what the court says in Kalidini versus Chintapalapati. This is another case, Munna Lal versus Kasibai. But in Satmoda versus M. Gunaya, the admissibility of a certified copy of a special wakalat for accepting a compromise signed by the lawyer under the wakalat filed in a proceeding 30 years old was accepted after it was found that the original which was in the district court was destroyed as per rule. A presumption was drawn in respect of the existence of the original wakalatnama. So, there are many those circumstances when old documents are not available. Something produced from the proper custody, court may draw some inferences from there. Jagdish Narayan case, wife of a deceased, a young woman of 25 years having 5 small children, an eyewitness of the incident turned hostile. Denial of session that she must have threatened with dire consequences, no advantage to defense. Wife definitely tried to conceal the truth, probably because the fear of the accused. In a normal Hindu family, it is unthinkable that the daughter-in-law would desert the in-law's house with 5 of her minor children after the death of her husband and would live with her parent unless driven by compelling circumstances to do so. What it is? Presumption. Court presume that a lady widow having 5 children, it is unthinkable she will leave in-law's home with all those many children and live in a parent place unless there is a compelling circumstance, unless they have been thrown out from those home, etc. So, these are the presumptions which are naturally comes. The presumption which in our day-to-day life we can naturally presume, court may also draw those kinds of inferences. So, law permit the court to draw such inferences which naturally we can draw. In the same way, for electronic record, there is a 5-year timeline. So, if a 5 years old electronic records are produced, court may draw some presumptions. So, where any electronic record purporting or proved to be 5 years old is produced from any custody which the court consider in particular case proper, the court may presume that the electronic signature which purport to be the electronic signature of any particular person was so affixed by him or any person authorized by him in this behalf. So, court talk about it. Section 81 has tried to explain the proper custody thing. There is another section in evidence law. It's abatement to suicide. So, a woman committed suicide within 7 years of marriage. Court may draw inferences she must have been subjected to cruelty. So now this naturally, why the women will commit suicide in in-laws place? So law helps in sometime proving the cases. So 117 says, when the question is whether the commission of suicide by a woman had been abated by her husband or any relative of her husband, and it is shown that she had committed suicide within the period of 7 years from the date of her marriage, and that her husband or such relative or husband had subjected her to cruelty, the court may presume, having regard to all other circumstances of the case, that such suicide has been abated by her husband or by such relative or husband. You know, in IPC, there is a penal provision, now become Nyaya Sanhita, we have the same penal provisions where the persons can be liable for abatement to suicide. So, anyone who abet to commit suicide, those are also liable. Evidence law or Bharatiya Sakshya Adhiniyam added presumption clause. Earlier it was section 113A, now 117. So, a woman within 7 years of marriage, if she commits suicide, subject to other circumstances, etc., where some evidence are there that the husband has subjected her to cruelty. So you got some evidences about cruelty, etc. So if those 7 years of marriage, suicide, those are cruelty evidences or some other circumstances of the court may draw inferences that definitely husband or in-laws or relative of such husband has abated suicide. Now what it do? It helps in proving the cases. So many times you might not have direct evidences, but through these evidences, it will help in proving some fact in the court. So that's the advantage of the presumption. So many times presumptions become an instrument, it's a means by which we prove something. And many occasions, these kinds of presumptions had its helps in proving the case. Remember, in these kinds of cases, abatement to suicide, etc., remember the women die at the in-laws place. Naturally, the in-laws or their relatives will not come to give evidences in favor of a women over the victims. The women are in the attached or away from their relatives, their fathers, their parents. Again, in those circumstances, getting direct evidence become difficult. When getting direct evidence become difficult, what can fill this gap? Presumption. So court may draw some kinds of inferences, and through inferences, court may presume that in-laws has abated it. Now, the most significant sections on may presume or presumption of fact is 119. Earlier it was 114. If you see this section, it is so broadly worded that whatever we naturally presume in our day-to-day life, this section talk about those kinds of presumptions. So what it says, the court may presume the existence of any fact which it thinks likely to have happened, regard being had to the, what are those? Common course of natural event, human conduct, and public and private business in their relations to facts of particular case. Very broadly worded. So whatever we presume naturally, whatever we infer naturally, under 119, law permit that we can presume those facts. It has given a long list of illustrations. For example, suppose there was a theft in your home. 100-gram golds being theft was committed from your residence. Now those all gold immediately after theft, within half an hour or so, the gold were found in the possessions of one of your staff, or maybe Mr. X. What we presume? Is it not presumption will be he must have committed theft? His thief? Because immediately after theft, you found this gold. This come naturally. Now suppose next day after 24 hours you found those gold in a goldsmith shop. What is the presumption? The shop, this goldsmith shop is the receiver of the stolen property. Now these kinds of presumptions come naturally. There was a theft at my home, mobile phone, laptop, some pad, iPad, etc. Apple's iPad was there, that's the being theft. Now, the thief where they sold out in a shop from where it was discovered, and he also arrested, he got thief along with the shop owner. What's the presumption? He must have stolen the theft property, he must purchase the theft stolen property. So these kinds of a presumption we can naturally draw, and because we draw the presumption naturally, law recognizes it. Be an accomplice in unworthy of credit. There are others. C, a bill of exchange accepted or endorsed was accepted and endorsed for good consideration. A thing or state of thing which has been shown to be existence within a shorter than that within which such thing or things usually cease to exist is still existence. Judicial and official work has been done regularly performed. So there are many things if the common course of business has been followed in particular case. G, evidence which could be and is not produced would, if produced, would be unfavorable to the person who withhold it. Suppose court asks you to bring X evidence. You say, I will not bring it. What could be the reason? Definitely when you withholding it, and you are under impression that if you produce it, it will go against your interest. No, this naturally comes. Why is not producing it? Definitely for that purposes. So there are something which we naturally draw, and accordingly law of evidence allow these kinds of a presumption. H, if a man refuses to answer a question which is not compelled to answer by law, the answer given would be unfavorable to him. So someone asks you some question, you say, I will not reply. Why are you not replying? Must be if you reply, it might goes against your interest. I, when a document creating an obligation is in the hands of the obligor, the obligations has been discharged. So some kinds of presumptions can be drawn. So natural presumptions, by different circumstances, law can draw those kinds of presumptions, and accordingly that what natural presumption is. So what we discussed today, we discuss about one aspect of presumption, which is natural presumptions. We call it presumption of fact. Now in the next video, you will find the second part of the presumption. We'll talk about presumption of law, and again there are two categories: rebuttable presumption of law, irrebuttable presumption of law. So see you again in the next video.